We've all seen the ads: a high-end mountain bike, a professional camera, designer bag, or power tools listed online on a Facebook marketplace for a fraction of their retail value. You think you found a great deal, but the district attorney, they think you found yourself a felony. In California, you don't have to be a thief in order to be treated like one in court. But there is a massive misconception about this law that the police and even some lawyers get wrong. They're going to try and tell you that you're guilty because you should have known the item was stolen. But that is not the law. I'm William Pernik. I'm a state bar certified specialist in criminal law in the state of California, and I'm a practicing attorney of over 20 years. Today, we're diving into Penal Code Section 496, the actual jury instructions the government will use to try and convict you, and the conventional as well as unconventional defenses that we use in these cases in order to protect you from being processed by a system that ignores your actual knowledge or criminal intent. Please watch to the end of this video, because I'm going to show you a highly effective method that I personally use here at my firm in order to fight back against these charges, and also give you a short list of tips and tricks, tools that you can use if you or someone you love and care about is accused of buying, selling, or possessing stolen things. To convict you of receiving stolen property, the government must prove 4 specific elements beyond a reasonable doubt under jury instruction Calcrim 1750. Criminal act. They have to prove that you bought, received, or concealed property that was either stolen or obtained by extortion. The government has to prove criminal intent, which is knowledge. Knowledge of presence, meaning that you were aware that the property was actually in your possession. Just because you ride in a car with someone who has stolen property in the trunk does not mean you're guilty. But if you know the stolen property is there, and especially if you confess to it to the police, then of course this element is met. Knowledge of status of property as being stolen. The government has to prove that you actually knew the property was stolen at the time you possessed or received it. If you honestly believed you were purchasing a legal item, you have a really good defense to this crime. Value. The charge of 496 PC is a wobbler in the state of California, meaning it could be either a misdemeanor or a felony. If the value of stolen property is over $950, it's a felony. Under $950 is a misdemeanor. In order to convict you of this crime, the DA has to prove what was actually inside your head. This is a 100% subjective standard. It doesn't matter what a reasonable person would have done. It matters what you knew. If the prosecution cannot prove that you were aware of the item's presence and aware of its stolen status, the law requires a not guilty verdict. Now, because the DA has to prove knowledge, cops will work extra hard in order to get that admission or confession out of you. That is why it is so important that you follow the advice I give in this and all of my other videos when it comes to talking to the police without a lawyer, especially if you are completely innocent. Without a confession, this becomes a completely different case. The DA can still try to prove the charge, but because they can't read your mind, they're going to have to rely on circumstantial evidence. They're going to have to point to a low price or a missing serial number and argue, hey, because these facts existed, he must have known the property was stolen. But here is your strongest shield, Calcrim 224. This jury instruction tells the jury that if the circumstantial evidence in your case points to 2 or more reasonable interpretations, one that you knew the property was stolen, and one that you were just an innocent buyer who was tricked or made an honest mistake, then the jury must adopt that interpretation which points to your innocence and reject the interpretation that points to your guilt as long as they're reasonable. If the evidence can be interpreted as an honest mistake, the law requires a not guilty verdict. It doesn't matter if your decision was naive, stupid, or if there was a better explanation. Now let's talk about the main defenses that you can have to the crime of receiving stolen property. Most of the time, we win these cases by attacking 2 different layers of knowledge. Defense number 1, lack of knowledge of the property's presence. I'll give you an example. Imagine you get picked up by a friend. You're in a passenger seat, and completely unbeknownst to you, your friend got a bunch of property in the trunk that they just got from a residential burglary. You're in possession of the car, but you're not aware of the presence of the items. That is a complete 100% defense. Defense number 2, lack of knowledge that the property was stolen. I'll give you an example. Maybe you bought a tool at a swap meet. There were dozens of vendors. It looked like a normal market situation. If you didn't actually know it was stolen, you haven't committed a crime. Defense number 3, mistake of fact. If you saw my video on residential burglary, you know I talk a lot about mistake of fact, which is one of my favorite defenses. That applies here too. Here's what mistake of fact means. If you legitimately and reasonably believe the fact that, if true, would make your conduct legal, you have a defense. If someone showed you a fake bill of sale, told you a convincing story that didn't seem patently unreasonable, or tricked you into thinking the item was legit, we can fight the knowledge element of the crime using mistake of fact defense. Even if the item is 100% stolen, your lack of criminal intent and your honest but mistaken belief is your shield. This defense is huge in a digital age. If you buy an item on Facebook Marketplace from a seller with 15 5-star reviews and the price is not suspiciously low, you can totally claim a mistake of fact defense. You reasonably believed you were buying a legitimate item from a seller who looked legitimate. Your intent was lawful, even if the item ultimately turned out to be hot or stolen. But what if your state of mind was compromised? Under California law, we can actually argue that you lacked the required specific intent or knowledge and get your charges dismissed. Intoxication can also be a defense. If you were so impaired that you didn't have the mental clarity to realize an item was stolen, or even that you had it, you cannot be convicted of this specific intent crime. This also applies to mental health crisis. If you were in a delusional state, or a severe manic episode, or a similar mental health crisis, you may have lacked the capacity to form the mental state or possess the required knowledge that the law demands. If we're successful in showing that to the jury, the charges against you will ultimately be dismissed. Now, if you watched my other videos, you've probably heard me talk a lot about our 3-step method, which is an analytical tool that my attorneys and I use here at the firm in order to understand our clients better and obtain much improved legal outcomes. This is how it works in cases involving allegations of possessing or receiving stolen property. Step number 1, find the why. We always look for the root cause behind our client's problem. Was it a factual mistake or a clinical crisis? If we're dealing with a factual error, we build legal arguments around lack of knowledge, mistake of fact, or possibly an intoxication narrative. On the other hand, if we realize that the driving force behind your conduct is clinical in nature, we will identify the substance abuse or the underlying mental health issue that either caused you to commit these crimes or motivated your criminal behavior or just contributed to your bad judgment. The second step is to develop a solution. Once we understand what that underlying problem was, we work with professionals, such as substance abuse counselors or mental health professionals, in order to identify a solution to make sure that this problem does not happen again. Step 3 is targeted solution advocacy. This allows us to build a proactive treatment plan, which we can then incorporate into our legal work and make the center of our legal advocacy in court. Because our approach is so successful at identifying mental health or substance abuse drivers behind criminal charges, we're often able to qualify our clients for powerful alternatives to criminal prosecution, and yes, help them avoid jail. These alternatives typically include participating in treatment-based programs called diversion, which exist for misdemeanor and felony cases, and sometimes exist for highly specialized, specific types of clients, such as persons with mental health issues, drug addiction, or special populations like military clients or veterans. One example is mental health diversion under Section PC 1001.36. If a mental health disorder played a significant role in the commission of your receiving stolen property offense, the court can divert your case into treatment instead of an ongoing criminal prosecution. This is a really great option to avoid a conviction for a stolen property charge if you ended up with stolen property due to an underlying mental health condition or drug addiction and are willing to address these problems in a structured treatment program supervised by the court. Common examples of something that could qualify would include a person who is compulsively buying and hoarding things online due to an underlying psychological problem, or a person suffering from depression or addiction or bipolar disorder who ends up putting themselves at high-risk situations by associating with the wrong people or using impaired judgment when buying or selling or even agreeing to conceal things. To get into this program, you would need to show that you have an eligible mental health diagnosis, that your mental health disorder played a significant role in obtaining or possessing this property when you should have known better, that the disorder is treatable and you are willing to participate in treatment, and that you would not pose an unreasonable risk to public safety if treated in a community. Military diversion under Section 1001.80 is another excellent diversion program. For veterans and active duty members suffering from service-related trauma, substance abuse, or other conditions, there is a program called military diversion. The biggest benefit of this program is that treatment is done in a specialty court with other veterans, using VA's treatment team and supporting resources, which is tremendously helpful to veterans going through a criminal case. The program for felony cases is very similar to mental health diversion for non-veterans. Whether you do mental health diversion, military diversion, or civil compromise, the biggest benefit is that successful completion leads to a full dismissal, protecting your record and your future. In cases of diversion specifically, you do not have to plead guilty to get diversion, and your arrest record will be sealed once it's completed. Misdemeanor diversion. For lower-level offenses, we can avoid a conviction entirely by participating in a general misdemeanor diversion under Section 1001.95 of the Penal Code. This program is much more discretionary and does not require mental health or substance abuse treatment per se, and we often use it in lower-level cases to avoid a conviction, especially if you're willing to pay restitution, perform community service, complete a theft offender class, or comply with other reasonable conditions that the court may want. With any diversion program, the biggest benefit is that when you complete the program, your charges are dismissed and your record is sealed. In the beginning of this video, I promised you that I would share our best kept secrets and give you some helpful tips and tricks on what you can do if you or someone you care about are being charged with or suspected of possessing or receiving stolen property. Here we go. Number 1, please stop talking to the police. If the cops are asking about property you bought, they probably already know or suspect that it's stolen. They're not there to help you figure it out. They want you to admit that you knew the property was there and that you knew it was stolen, so that the DA can convict you more easily. The more you talk, the easier you make it further. You're not going to talk your way out of an arrest. All you're going to do is create a recorded statement where you get confronted with facts and make a poor excuse for how you should have known better than to buy or sell the stolen goods. Number 2, refuse the search. If the cops ask you to search your trunk, your trailer, or your home without a warrant, they're likely acting on a hunch. If they had the legal right to search, they wouldn't be asking for your consent. They would be showing up with a warrant. You don't have to be rude or fight the cops as they try to search your property, but please be smart. Don't waive your Fourth Amendment rights. If the police search your property illegally, your lawyer can later file a motion and get this evidence thrown out of court for violating your rights. But if you consent to a search and they find evidence of your crime, it will 100% be used against you in court in order to convict you. Number 3, lost property is not finders keepers. If you find a wallet with $1,000 in it in a hotel lobby and you decide to keep it, that is Penal Code Section 485, conversion of lost property. Just like Penal Code Section 496, it too can be a felony if the property is valued over $950. So if you find someone else's stuff, please be smart and either make reasonable efforts to find the owner or leave it alone. And definitely do not help yourself to it. Number 4, confirm legitimacy online. If you are buying and selling things online, please be sure to check that the stuff you're buying is actually legit. If there is no proof of ownership and the price is too good to be true, walk away. You're buying yourself a felony, not a bargain. Number 5, the innocent intent window. If you realize you bought something that's likely stolen and your intent is to turn it over to the police, that temporary possession of property can actually be a defense. But please be smart, be careful. Talk to an attorney first so we could facilitate that return without you incriminating yourself in a process. Number 6, the immigration and professional license warning. Please beware, all theft-related crimes are crimes of moral turpitude. For non-citizens, that means that this could result in your deportation, denial of naturalization, or adjustment of status. And for professionals, for those of you who hold a professional license, this could be the end of your career. Number 7, please be careful with who you hire to represent you in your case. When it comes to hiring an attorney on a criminal case, please be sure you're working with someone who's an experienced criminal defense lawyer, and not just someone who did your uncle's divorce or helped you on a landlord-tenant matter. Anytime your freedom and your reputation are on the line, you need a specialist who understands how these cases are handled, who knows the local customs, and who is familiar with nuanced California alternatives like diversion programs that may be totally outside of common knowledge for an outside, non-criminal law practitioner. If you're facing a charge for receiving stolen property in the state of California, I hope you found this video helpful. Please visit us at perniklaw.com, hit the like button, and subscribe to our channel for more insights on how to protect yourself and stay out of trouble. And if you like this video, please check out also my related video on residential burglary and how to protect yourself against that charge.